Well, our port of call before starting to look at the provisos proper is section 95, page 737 of the electronic bundle. Authority 1 for those of us using the bundles. This is the power in the Secretary of State by regulations to prescribe standards of performance in connection with the provision of sewerage services. It has an exact analogue in section 38, similar power to prescribe regulations for standards of performance for water provision, if you're concerned with that. The key point to note about this section is it effectively enables by regulation the Secretary of State to provide that part of the relationship that is not the price. Because the peculiarity of the relationship between a water or sewerage undertaker and its customers is not a relationship, at least in the case of dwellings, grounded in contract. Indeed, contracts are prohibited by section 142(2)(a), page 917 of the bundle. 143 and following sets out the process by which the price element of the relationship, the statutory relationship, is set. And what 95 does is enable by regulations the rest of the contract, if you like, the rest of what would be the contract, to be provided by way of regulations setting out the service standards. And that regulates things like, as I mentioned to Lady Rose, continuity or breaks in performance as part and parcel of a effectively breach of the service relationship. And it's understanding that background to the regulations that understands what's going on here, because in effect this is the proxy for the contract that would otherwise subsist and does in the case of retail supply to companies that are entitled to contract rather than those in dwellings. And what it does, in particular, in 1A, allows by regulations the Secretary of State to flesh out the contents of the drainage duty, and as we'll see, the 94 urban wastewater treatment regulations do that. And then by 1B, it allows the fleshing out of standards of performance in the relation to the provision of sewerage services. And contraventions of those requirements shall be treated as breaches of the relevant duties, section 94 duties. Then subsection 2 is also important. The Secretary of State may, in accordance with section 96 below, prescribe such standards of performance in connection with the provision of sewerage services as, in his opinion, ought to be achieved in individual cases. And what that is telling you is it's about the individual service provision to customers or categories of customers. And then regulations may provide that if you fail to meet a prescribed standard, you shall pay such an amount as may be prescribed to any person who is affected by the failure and is of a prescribed description. And then 4 provides for regulations having the power to engage Ofwat in dispute resolution procedures in relation to service provision. And it's that role that explains why this is one of the provisions, if you go back to section 2, that engages Ofwat's duties, because obviously those duties will be engaged when deciding these disputes. 3 things to note about this provision. I think it's an open question, and probably a difficult one, and not for resolution now, whether it confers any virus at all to prescribe standards in relation to somebody who is outside the service relationship. Obviously, that wasn't the problem in the Marchich case, because Mr. Marchich was in receipt of services as a residential customer of the water company. But it's a nice question as to whether or not this enables the prescription of standards that are vis-a-vis parties that are entirely third parties. The second thing is that all that is provided for is a power to provide for fixed sums payable in fixed circumstances. And that is, we would respectfully say, effectively akin to a regime of strict liability. And there is no problem of concurrence of that remedy with general remedies in contract, in nuisance or trespass, where the loss far exceeds those sums. That was, in effect, the question grappled with by Mr. Lord Justice Higginbottom in the Southern Gas Networks case in the bundle, and he concluded that a similar scheme in a similar context, regulated utility, didn't exclude wider claims of nuisance. And that's because this isn't intended to be a regime of compensation like that in Schedule 12, providing for tailored payments and compensation according to damage suffered, if it was, it would look like Schedule 12. And it doesn't. It's doing something very different indeed. And then the last point to note...
So you don't have to prove any loss or damage?
No, it's just a fixed sum. You get £500 for every incident of sewage in your garden, whether it's 1 foot of your garden that's flooded or an entire 5-acre garden. It's a fixed sum in all circumstances. And then the last point to note is what you're told about the relationship between Section 95 and the rest of Part 4, Chapter 2. Go back to page 726. You're told that whatever provision is made under Section 94 or 95, and this is my Lady Rose's question about what such provision is, that any such provision is, doesn't in any way qualify what happens in the rest of the Act. So that is, I think, a series of points that's highly germane to any contention that this constitutes some form of general regime or adequate regime of compensation. Then we transition from Part 4, Chapter 1 into Part 4, Chapter 2. And that starts at Section 98, page 748, the duty to comply with sewer requisition. And it embraces matters like that, the very important duty to connect at Section 106, or right to communicate with public sewers, that's page 803. This is the basis of the obligation at the heart of the Barrett litigation, my Lord Lloyd Jones will remember. It's the basis of the obligation to connect people, whether or not that has implications for the capacity in your sewers. And it's that duty to connect that might lead over time to a well-designed sewer that hasn't been upgraded, lacking capacity. And then the critical provision for our purposes, because it's at the heart of Manchester 2014, is Section 116, the power to close or restrict use of public sewers. And it's what we call in our written case the duty of continuing provision. Why do we call it that? Because you can only close a sewer if you've already made sufficient alternative provision for another sewer to replace it. And it was on the foundation of that obligation that the Supreme Court in the 2014 case found an implied power of discharge. So that's a critical provision for our purposes. Then we come to the first of the provisos at 860. The first thing to note is the heading, Interpretation of Chapter 2. And that means that this proviso only applies to the sections from 98 and following, and in particular for our purposes only applies to section 116. It does not apply, and therefore was not cited in, the section 94 duty at the heart of Marchech. It's the first point to note. Then we have the critical elements in relation to this, and they are at 5 and 6 after the definitions. Nothing in sections 102 to 109 above, or sections 111 to 116, so check, we're in that space once we're dealing with a power of discharge, shall be construed as authorising a sewage undertaker to construct or use, and it's use that's the operative word there, any public or other sewer or drain or outfall that would A, contravene a permit under the environmental permitting regulations, or B, for the purposes of conveying foul water into any natural or artificial stream, watercourse, canal, pond or lake, and we're assuredly in the terrain of watercourses or canals, without the water having been so treated as not to prejudicially affect the purity and quality of the water in the stream, watercourse, canal, pond or lake. Now that is a section that says in terms, there shall in these circumstances be no authority to do the things you otherwise have authority to do under this part. And it's that proviso, when linked with the implied power of discharge in section 116, that sets a statutory limit on the lawful use of the power of discharge. If you exceed the terms of 1175A or B, there is no defence of statutory authority either to the prosecution or to the consequences in common law. And this section makes no sense at all unless it's predicated, as is the general background assumption, unless contrarily indicated clearly by the statute. See the Lachaud case we cite in our case. It operates on the basis that the common law is operating in parallel, because it's a section that otherwise is meaningless. It's OTOs. It has no useful function unless it's intended to confer a limit or impose a limit on the scope of statutory authority. And any doubt on that is, with respect, removed by the next section, which says a sewerage undertaker shall so carry out its functions under those sections as to not to create a nuisance. Again, the clearest possible indicator that the common law is intended to run in parallel. Now, just step back and do this mental exercise. You've got the express ouster rule in 18.8 that identifies categories of claim that can subsist. You've got the speeches in Marchich accepting, at least Lord Hoffman and Lord Hope do, that a claim simply formulated in nuisance is compatible with the categories of case that are allowed to continue. And now you have a provision dealing with the implied power to discharge, saying you can only discharge if you don't prejudicially affect the water or you don't create a nuisance. And you ask yourself this question: how can I read these provisions as ousting a claim in nuisance or trespass compatibly with the principle of legality? And the answer, I would suggest, is obvious. It is to denude these provisions of the very function that they were intended to operate as, i.e. as saving provisions that limited the extent of permissible statutory authority and demarcated the extent to which private law continued to run in parallel.
Sorry, which of these sections are we concerned with? You mentioned a moment ago, I think you said one of them.
Both of them are engaged.
No, I'm sorry. Of the sections referred to in subsections 5 and 6, which ones are directly relevant in this case?
1175B and 117...
Sorry. Of the sections referred to...
Oh, 116, my lord. It's 116.
116.
It's 116, because it's 116 that contains the implied power identified by this court in the 2014 case, which is the power of discharge.
It's odd to include that provision if it has that effect in a section which is headed Interpretation of Chapter 2. What's it got to do with interpretation if it has the effect that...
It has this effect in terms of interpretation. When you are, as the Supreme Court, conducting the interpretive exercise in 2014 to see whether any of these provisions contain an implied power of discharge, this section on interpretation requires you to conclude that there is such a power, but it has such limits.
Yes, well, I mean, that subsection 5 says in terms, nothing, ... shall be construed. So it is an interpretative instruction.
It is.
And you say subsection 6 is supportive of your interpretation of that subsection.
Exactly so, my lord.
Yes.
Spelling it out, are you saying that the implication of subsection 6 is that it is possible in law for a sewerage undertaker to carry out its functions under section 116 in such a way as to create a nuisance? Otherwise, of course, there'd be no need to prohibit it from doing so.
That's right.
But the effect of a subsection is to impose on it a duty not to do that.
Indeed so.
Or
And that,
a statutory duty, I suppose, in addition to
and
the
that
common law
duty
duty.
must exist as a limit on the power conferred. That's the key point. That many of the limits that are identified for statutory powers are identified by implication. So the whole Allen and Gulf Oil, the whole Metropolitan and Silent and Hill case law is all concerned with spelling out implied limits in powers where the statute doesn't spell it out expressly. But again, just like with section 18.8, here you have an express rule telling you in terms the limits on certain interpretive exercises here to find an implied authority. And the critical thing, we'll see when we come to the 2014 case, is that Lord Sumption's speech in particular, but also Lord Toulson's, alighted upon these provisions and effectively reunited the implied power of discharge in section 116 with the proviso that had applied under the old legislation, under a case called Durrant and Branksome. And effectively, in that way, he ensured continuity of the law. The law had always been that there was an implied authority to discharge clean water, but only clean water. And that stemmed from the old section 17 of the 1875 Act. So this provision, on any analysis, if you're doing a Pigott analysis and you're looking for the particular power and the limits on the particular power, it's this section, along with section 186.3, which I'll come to momentarily, that tells you what the limit on the power is. And that, you have my submission, is the starting point for analysis. Now,
this section is not one enforceable by means of a Section 18 enforcement order, I think.
it's not, my lady, no. It's not part of the statutory requirements to which you've seen the definition in section 18.6.
Because it doesn't say anywhere in it that it's...
No, because what it's predicated on is a continuing obligation at common law.
Mr. Delaneyers, both section 117, subsection 5, and section 186, subsection 3, use the language of authorisation.
Yes, and that's relevant.
Any significance in that?
Yes, my lord, because it's telling you whether or not the activity in question falls within statutory authority. And if you go back to my opening predicate, you expect statutory authority, compensation, and ouster to march hand in hand. An orderly, coherent principled system is not going to oust claims in relation to something that is neither authorised nor compensated. And what this is telling you is effectively the limits of the extent of the defence of statutory authority, both in the criminal context and in the context of potential tortious claims. But if it wasn't clear enough from this section, which can only meaningfully be comprehended on the basis that common law tort claims, property tort claims, are running in parallel, it's yet clearer still from the second of the provisos, section 186. Because, and that's at page 952, this section, and I put my case this high, is literally incomprehensible, meaningless, jargon, waffle, rubbish, if there is no parallel application of the common law. Because the whole point of this section is to make, in a number of identified cases, limited qualifications and limited consequential ousters on the substantive law of tort in relation to nuisance and trespass, and limited procedural adjustment as well. So let's look at the section and let's look at all of it. It's 186.3 that's of critical relevance, but the rest of the section also helps understand what's going on. 186.1 is to do with things that might affect the workings of sluices, floodgates, groins, or works for irrigation. And it says, nothing in the Act shall confer any power to the person to do anything except with the consent of the person who so uses them, which interferes with those things. So the first thing is, what is consent in this if it's not consent backed by the common law, which ordinarily requires you to have consent to do these things, which would otherwise amount to a nuisance or trespass? The whole idea of consent doesn't make any sense unless it's some form of enforceable right sitting behind it. And that is backed up by section 186.6, which applies only in relation to subsection 1. A consent for the purposes of subsection 1 may be given subject to reasonable conditions, but shall not be unreasonably withheld. And what that's telling you is that the ordinary law of trespass is being modified because the ordinary landowner's right to refuse on whatever grounds they refuse and seek whatever terms they may seek for access to trespass on their land, etc., is being modified by a requirement of reasonableness. That's only in relation to the 1861 cases. Then look at 186.3. Nothing in the relevant sewerage provisions, I'll show you that definition in a second, shall authorise the sewerage undertaker injuriously to affect any reservoir, canal, watercourse, etc., the supply or quality of fall of water contained in or any feeder, etc., without the consent. So again, we have the keyword consent. What can that mean unless it's an enforceable, backed by an enforceable right, of any person who would, apart from this act, have been entitled by law to prevent or be relieved against any injurious affection. So what it's saying is trespass and nuisance. So you're entitled by law to do those things. So the nub effect of this is it's saying nothing in the relevant sewerage provisions shall entitle you without consent to injuriously affect the things identified, which include water quality into the canal, watercourse, etc. Again, that section is literally incomprehensible without the assumption being that the common law rights are running in parallel and this section is directed at them. And then you come on to
Well, why
186.
does it say who would, apart from this act, have been entitled by law? Why doesn't it just say who is entitled by law?
Genuinely, I don't know.
There must be a reason.
Probably one for Mr.
It suggests that there's something in the act that
Well, one
takes
answer,
away the right to prevent
yes,
it.
one of the answers I was about to say might lie in the next provision I'm about to take you to, which is 1877.
Right.
Because what this then does is modify the substantive rights and modify the procedure. So 187...
Before going on to that, why is it that a landowner can consent to an individual breaching their duty under section 94?
This is consenting to injurious affection of their land.
Yeah.
And it may be through volume of water, it may be through pollutants, etc. The fact is that in order to do those things, you may need to show that it's compatible both with the law and with the property rights of the person in question. And the whole rationale of this section doesn't make any sense unless it's predicated upon there being that right to secure consent or payment. And then 187...
I'm just thinking, depending on the facts, if you're thinking about, for example, a river, there might be quite a large number of people whose consent would be required.
Yes. Yes. Precisely that point is made by Lord Justice Keane in the BWB case by reference to this very provision. Then 1867, any dispute as to whether anything done or proposed to be done will interfere with groins, etc. So there's a topic, a subject of factual inquiry allocated, as we'll see, to an arbitrator. That's not our case because we're not the focal point here.
Does the consent, can the consent in 1863 be unreasonably withheld, or is the same requirement of reasonableness apply to that?
We say it can, and that will turn upon the interaction between 1866 and 1867, because 1866 goes out of its way to say we're controlling consent for the sluices and irrigation cases, but nothing else.
Subsection 1 only, yes.
Yeah. But I agree, it's not clearly drafted.
It looks as if it applies more generally.
I agree, my lady. It's not a decided point. My submission is that the references to consent in 7B and C are necessarily to sluices and floodgates cases rather than 1863 cases. Then B, that topic...
Is there any reason why you should be able to withhold your consent unreasonably in relation to 3 but not 1?
I think the best answer I can give to that question, and it's certainly one I've scratched my head about, is that 1863 is concerned with private landowners as a general cohort, whereas in relation to sluices, floodgates, irrigation works, etc., you're already dealing with an activity that entails interaction between one set of land and another. If you see what I mean. The minute you're building sluices, floodgates, groins, sea defences, or irrigation works that take water from the stream, there are immediately consequential effects from that activity for other landowners. And that may be the reason for the location of an obligation of reasonableness. It's a bit like a statutory rule of give and take that applies in the reasonableness test in the tort of nuisance.
So is it only D in subsection 7 that would be relevant?
I was trying desperately to get there, yes, that is the point. So B and C make any dispute about consent mandatory subjects for arbitration, and then D is this case. And it's as to disputes as to fact whether or not there's been injurious affectation in 1863. And the scheme of 7 is that if you fall into one of the 4 categories of topic in A to D, A to C gives rise to mandatory arbitration. And 1867D, our case, says it's arbitration at the election of the party complaining. Now that raises the question, what are we arbitrating? If nuisance and trespass, which are the basis for requiring consent, are removed, and in particular, if there's no operative rule of reasonableness into the 1863 cases, what on earth is this section doing? It is only comprehensible if what in fact is occurring is a series of limitations, substantive in the case of consent where it applies, procedural in all cases by requirement to go to arbitration, that limit the operation of the law as it would otherwise function. And the critical thing to note about the arbitration is that the arbitration is directed either to an arbitrator appointed by agreement between the parties or by the president of the Institute of Civil Engineers. In other words, the types of factual disputes arising about sluices, groins, injurious affection, etc., are appropriate for that type of technical expertise and are directed in that place. This section makes no sense at all, literally no sense at all, unless trespass and nuisance are proceeding in parallel. And it is, once you understand it in that way, exactly of the same ilk as section 1175, and has exactly the same sort of function. It is.
But what then happens? Suppose you go to the arbitrator and he or she says, right, well, I think that the water was injuriously affected.
Yes.
So then what?
Then you go back to the courts of common law and you enforce the consequences of that in your cause of action. The topic that has been identified here, have you or have you not reasonably or unreasonably withheld consent, has there or has there not been injurious affection, are answered by the arbitration, and the consequences of that, in terms of relief, in terms of damages, are then left to the common law, because what there isn't is a power in the arbitrator to determine the compensation flowing therefrom. And again, the very fact that this is only a partial ouster of the operation of the relevant torts is proof positive that...
But just to spell out some of the steps that are, I think, implicit in what you're saying, but which you haven't made explicit. You have a subsection 7 envisages various types of dispute.
Yes.
And the first 3 types of dispute have to be referred to arbitration.
Yes.
And there must be some means of enforcement of the order of the arbitrator, otherwise it's a pointless exercise.
Yes, but the arbitrator is only given that mandatory jurisdiction in relation to very narrowly described topics.
Yes. Now, in relation to the 4th, D,
Yep.
that's dealing with 1863.
Correct.
And there, the dispute can be referred to arbitration at the option of the party complaining.
Correct.
Now, the implication, I think, you're drawing from this is that the alternative for the party complaining must be to go to the courts.
Yes.
Because if arbitration is optional, the dispute, there must be some, I think you're telling us that by inference there must be an alternative means of resolving the dispute which is available, And that would have to be the courts.
It's enforcing the requirement for consent. So here are a series of things that aren't addressed or ousted by this section. If I, the person making a discharge, never seek consent and say that there's no requirement for consent, that's not caught by these provisions. So I have my recourse to common law.
Wouldn't, I'd raise it just to find what your answer is. Wouldn't an alternative complaint be a complaint to the Environment Agency or to Ofwat?
It wouldn't, my lord, because the whole focus of this section is a focus upon the fact that absent this act, you're entitled by law to prevent or to be relieved against the consequences of the action in question. That's the whole subject matter of debate. You're debating a section whose operation is directed at the common law rights that would otherwise give rise to a requirement for consent or statutory authority.
Why does it exclude the alternative as being a complaint to Ofwat or to the Environment Agency?
Why does it exclude it? Because nothing in a complaint to Ofwat or the Environment Agency provides any legal foundation to insist upon consent. And what one's looking for is a legal foundation for an ability to insist upon consent, to have a dispute about consent. I can't take a dispute to court about Ofwat's decision whether or not to grant consent as between the different parties. It's a completely different subject.
Yes, and I suppose it might be supportive of your position that the complaining party has the option to go to the Institution of Civil Engineers on the question of injurious affection, which
Absolutely.
would be something that would be a technical matter which the common law courts might not necessarily have the same expertise,
Absolutely.
but the Environment Agency and Ofwat might. So it might be pointing towards getting one matter taken out of the common law action, the technical matter, determined by a professional. So you'd stay the common law action under Section 4 of the Arbitration Act to get that technical ruling.
Absolutely.
And then you go back to the court.
Exactly so, Will. So to give the list of examples, the party doesn't seek consent at all, this section doesn't bite, at which point its logic is you have the rights you always had because the party's not sought consent. If they do seek consent and you refuse it reasonably, and the arbitrator decides you've refused it reasonably, and they've gone ahead and done it, you go to the ordinary courts to enforce that. If the arbitrator decides that it was unreasonable for you to consent, but the terms and conditions you would seek if you had to give consent were reasonable, then you go to court to enforce those terms and conditions if they're not complied with. If the party doesn't pay the sum that's made reasonable by the conditions and accepted to be reasonable, then you can enforce it in the ordinary way. All of the steps in these various different topics are predicated on, at some stage or other, the necessity for enforcement through the private law if the parties don't do what the law otherwise requires. And it's a section that, with respect, is gibberish if there's total ouster of trespass and a nuisance.
You say it is an ouster insofar as ordinarily you can refuse your consent
Yes,
to a trespass. for any
absolutely,
reason.
my lady. So to that extent, in a sluice's case, has the law, ordinary common law, been modified? Yes, it has. And in that circumstance, you're not entitled to insist upon consent if an arbitrator appointed says it's unreasonable. But in all other respects, your rights continue.
I mean, I see the force of the point you're making in relation to subsection 7, read with subsection 3. But, Marchick doesn't actually, the effect of Marchick is not to oust all claims in nuisance and trespass. I mean, there could be damage to the quality of the water, which doesn't engage any Section 94 considerations, any requirement to build new infrastructure. So there might be an escape of some toxic substance into the canal or into a watercourse. So, I mean, it's not that, Marchick doesn't rob these provisions of all content. I do see the point you're making, but I think you perhaps just might need to address that.
Well, I'm not sure, with respect, madam, that I agree with that,
Because the basis of Marchik is that liability, private law liability, is excluded or ousted where where the injury, whatever, the nuisance, can only be abated by the construction of new infrastructure. That's right, isn't it?
yes,
Well, you could have the undertaker could, as I say, I mean, not deliberately, obviously, release some toxic material or something into a watercourse without the need for any new infrastructure.
yes,
They're just
that would be a breach of section 94(1)(b) and the obligation to effectually treat.
yes, but it doesn't engage the obligation to make new infrastructure, which is the point that lies at the basis of Marchik.
Well,
it's the balancing of the various interests concerned that is what seems to have animated the House of Lords in
Well,
that case.
again, with respect, my lord, I'm not sure I agree with that.
I see.
Let me give you an example of a very common problem. Not necessarily sewage as such, but the amount of phosphates going into waters, which creates algal blooms and growth. Water companies are obliged to treat phosphates as well as sewage coming through the water supply. And when one looks at the urban wastewater treatment regulations and the environmental permitting regulations, you'll see that they both apply to a wide definition of wastewater. And so I'm not sure, with respect, that my Lord's example, in relation to the activities of a sewerage undertaker, actually works. Because, okay, the focal point is household sewage, but other things go into the sewers as well, including industrial effluent. Yeah. And all of that has to be treated. So, with respect, I don't think I accept the premise of the question.
So your submission is that there is no claim that could be brought under, I mean, indirectly 1863, or to which 1863 could relate, let's say, which is not covered by the Marchik decision.
Yes, but it's also more fundamental than that, my lord. The whole notion of the consent that would otherwise be required for the purposes of this section only makes sense if you understand that it's the consent that would be required by virtue of you having enforceable private rights.
No, I follow that.
Yeah.
Yeah.
I should show you the definition of the relevant sewerage provisions. They're at page 961. The definitions start at 957 if you're looking for them. The relevant sewerage provisions are chapters 2 and 3 of part 4, so they don't include chapter 1, which is the chapter including section 94. So nothing about the breach of section 94 is anything to do with the relevant sewerage provisions. And you can see it's
catching up with you. Sorry, what page?
961, my lord.
Thank you.
And this is section
This is the definitional section 219.
219.
Yeah.
Did you say? Yes. Thank you.
And you can see that the first limb of the definition encompasses, and this is the critical thing, encompasses section 116, what you're looking for with all the provisions. So section 116 is not in the exclusions bracket. And that means section 116 is one of the relevant sewerage provisions, as is 117. And that then tells you that the whole topic of implied discharge and the limits thereon are part of the relevant sewerage provisions. Now, the relevance of that is, as I've already shown you, 1863 only applies to the relevant sewerage provisions, but we know, putting the two together now, that it applies to implied discharges under 116. And then you see that relevant sewerage provision definition again in Schedule 12, page 971, which is the compensation provision. Subject to the following provisions of this paragraph, a sewage undertaker shall make full compensation, that's the point I made to Lady Rose, to any person who has sustained damage by reason of the exercise by the undertaker in relation to a matter which that person has not himself been in default.
Sorry, Mr. Delamo, where are you reading?
971, paragraph 4 of Schedule 12, my lord.
Thank you very much.
The compensation provisions. So it concerns the exercise of any of the undertaker's powers under the relevant sewerage provision. And the simple point is, there is no right to statutory compensation in relation to an excessive use of those powers. And that was the conclusion my Lord Jones reached in Bromley number 2, at the passages we've cited in our skeleton. So this provision, as is entirely commonplace, aligns with statutory authority and with lawful use of powers. So, that's topic 5, done and dusted, probably the densest one on our list. Let me rattle through a couple of the others. I see the hour, and I appreciate the pressure of time I'm under. The 2014 decision, my topic 6. This was the culmination of a series of cases about statutory authority to discharge. And the result in the 2014 case can't really be comprehended without understanding the BWB litigation which came before it. BWB concerned a Canal's body which had previously consented to the discharge into their canals, withdrawing their consent and effectively seeking to engender a new negotiation for consent. And the utility company in question, instead of playing that game, said, well, in fact, we have an implied power to discharge into your canal. And the issue was whether or not there was an implied power. Then it was located under section 159 of the Act, the pipelaying power, which is not one of the relevant sewerage provisions. And Lord Justice Peter Gibson overruled Justice Arden, as she then was, in her conclusion there was such an implied power. And the reason for that conclusion was that the implied power argued for was in section 159 and not in chapter 2 or the relevant sewerage provisions. That meant none of the provisos applied to control its exercise, so that the power of discharge would be unlimited as to what would be permitted to be discharged. A conclusion, see paragraph 42, page 2052, which he thought necessarily implausible. And since there was, it was common ground, no authorisation to commit a nuisance, Mr. Beloff having conceded as much, see paragraph 36, and there was no challenge to the notion that a discharge, unless authorised, would be a trespass, see paragraph 37. Those factors, combined with the fact that there would be no compensation, because Schedule 12, Para 4 would not apply, because this was not one of the relevant sewerage provisions, militated completely against there being any such implied power as from 1991 onwards. Instead, Lord Justice Gibson concluded an undertaker could either obtain consent by paying for it, or seek to exercise its generous powers of compulsory purchase to obtain the required authority to discharge. See paragraph 41. 2052. Lord Justice Chadwick's analysis was to the same effect. He placed very considerable emphasis on the provisos at 57 and 66, and in particular upon the absence of any restriction akin to that in section 1175 upon what could be discharged. Also addressing, in particular at 69 to 71, the absence of compensation, which told against there being any such implied power. And see, in particular, and it's probably worth turning this up, what he described as the fallacy in the case at page 2062, paragraph 71. The fallacy, as it seems to me, lies in the underlying but unspoken premise that Parliament must have intended that sewage undertakers should have facilities to discharge, which plainly they do require in order to carry out their functions, without paying for those facilities. Whether or not that premise could have been supported in the context of a public authority charged with functions imposed in the interest of public health, it cannot be supported, as it seems to me, in the context of legislation enacted following a decision to privatise the water industry. And that conclusion, we would suggest, is a fortiori in the case of something that, as it now transpires on the proper analysis of the powers, is entirely unauthorised. And then Lord Justice Keane, at page 2064, drew in particular upon section 1175 at 81 and 1863 at 83 before making his comments at 2065. In our written case, we suggest that these might be obiter, but I think having reconsidered it, they're not. And the reason they're not obiter is that they are central to the judge's conclusion that there is no statutory authority. Because what he's saying is that the only comprehensible purpose of these provisions is to save the operation of the common law. They are savings provisions, as they've often been described. And if that is the case, and the common law is being saved, it must follow, as a matter of logic, that there was no implied power to discharge. So that is, with respect, ratio. And that is precisely the analysis that we advocate in relation to these provisos. What then happened was that Manchester Ship Canal issued proceedings for trespass and nuisance, and UU defended those proceedings up to the 2014 case on the basis that in relation to pre-1991 discharges, i.e. discharges in existence before the Act came into force, there was nevertheless some form of grandfathered implied right. And UU's case, and we put their case in the bundle, and it's well worth a read because lots of it appears quite inconsistent with what is argued now, not least in relation to compensation. UU's case was that implied power was to be found in section 159. And that argument was rejected by the Supreme Court, that instead located the implied power in section 116, the duty of continuing provision. And if I could ask you very briefly to look at this Supreme Court decision in that case, it's 1096 in the electronic bundle, authority bundle 2, tab 4, for those working on the hard copy.
So just give me the page again.
1098, my lord.
98.
Yeah. The first thing to note is that the court rejected the invitation from UU to overrule BWB. Far from it. If you look, for instance, at the speech of Lord Sumption, he says, it's good law, and we refuse to overrule it. Paragraph 15, page 1106. Reasoning was compelling, and the reasoning was, there's no provisos and no compensation. You're asking for an unfettered, unlimited power to cause a nuisance without compensation. Instead, what followed at paragraph 16 and following was an analysis that located an implied power in section 116 that then meant that the implied power was accompanied by the proviso in 1175, and effectively, thereby, the implied power was reunited with the conditions that limited its use, just as had been the law under the Durrant and Bragson case cited at paragraph 20, 1108. And in particular, the merit of this approach, 22, was that it didn't leave the owners of private watercourses in a worse position than they were under the Water Act 1989 or previously, because of a more limited provision for compensation for damage and the more limited protections available against abuse. And what Lord Sumption is saying there is if you'd located the power in section 159, Schedule 12 wouldn't bite. But because it's been located in one of the relevant sewerage provisions, section 1863 will bite, and because it's been located in section 116, which is in chapter 2 of part 4, 117 will bite. And that means, effectively, we go back to a principal solution where there's statutory authority, limits on the statutory authority, and compensation for damage caused for actions within the statutory authority. Lord Toulson agreed. The only thing he also additionally noted, paragraph 32, is that this would also revive the application of section 1176, which requires a sewerage undertaker to carry out its functions in such a way as to not constitute a nuisance. And then Lord Newburger reached what one may call, with no disparagement intended, very much more chancery solution based upon historically acquired rights. And he basically said that the old right recognised under the old Acts survived by dint of section 16 of the Interpretation Act, together with the burden it contains, namely the burden in the old section 17 and the obligation to compensate under the old section 308. And so he arrived at exactly the same conclusion, that there was an implied power, but it was subject to the proviso, the old proviso, and an obligation to compensate. Now, his view was the minority of one. But what is also important, again back to the principle of legality theme, is his emphasis at 58.
He wasn't a majority of one.
So it's a minority of one, is what I mean.
No, well, it's not, because Lord Clark and there were two other judges who agreed.
I'm
with
sorry,
him.
so sorry, Member, that's right.
It's a majority judgment.
It's a majority judgment. Do forgive me. The majority is the approach of Lord Sumption, Lord Clark, and Lord Hughes, and Lord Toulson, who substantially agrees with them, because he locates the power in section 116 as well.
Well, it's also Lord Newburger's judgment is also agreed with by a majority.
I'm sorry, my lord?
Lord Newburger's judgment, I haven't checked it, but I believe it was agreed by Lord Hughes and Lord Clark, wasn't it?
It is page
So that's a majority judgment.
1111, just after paragraph 37.
Yes, you're quite right, my lord. The plot thickens. In any event, the place in the Act where the power of implied discharge is located by 4 of the justices was section 116.
And what Lord Newburger finds in the last, well, he sums it up in his last paragraph, that the sewerage undertakers continue to have a statutory right to discharge surface water and treated effluent from existing outfalls
Yes,
from sewers vested before 1991.
yes. But however you cut it, whether it's by dint of reuniting 116 with 117, or by effectively the continuation of the old provisions that made the old implied authority to discharge subject to the proviso that was then found in section 17 of the Public Health Act, you have a power to discharge that is conditioned by limits set by Parliament. That's the critical feature in my section, and accompanied by compensation. All of the judgments require that analysis. And that's consistent
And it wouldn't be a right to discharge what we're dealing with in the present case.
No, that's the point. On none of the analyses would that be authorised. It would be breach of the proviso or breach of the old proviso, and if it had been lawful, it would have required compensation. The point I was going to make about Lord New...
So Lord Clark and Lord Hughes agreed with both Lord Sumption and Lord Newburger, in
Yes.
fact. And Lord Toulson, you say, is most consistent with Lord Sumption.
Yes, he is.
So maybe one of those cases where
It is one of those cases.
there are two ratios, and the people concurring have agreed with different ratios to the same result.
But the hack advocate in me wants to say, whichever route you take, you arrive at a conclusion where the implied power is subject to a limiting condition identified and set by Parliament, and it's accompanied by a right to compensation for actions within the limit of the statutory authority. Whichever analysis you adopt, that's the end result.
Yes.
That's the end result they both get to.
Yes, Lord Toulson at paragraph 35 gets there by through sections 1175 and 6, that there's a right to continue to use the old sewers,
Yes.
subject to the qualifications that the undertaker mustn't cause pollution or a nuisance.
That's exactly the same reasoning as Lord Sumption. The point I was going to emphasise at 58 is Lord Newburger's insistence that the court should not be easily persuaded that a new right has been created by implication, particularly when that right interferes with the private rights of third parties, in this case waterway owners, and arises out of a long and detailed statute. There is, in my view, a very strong presumption, that's how he puts it, this is principle of legality, again, that private rights are only to be taken away by a statute by means of clear and specific words, and two, where a statute deals in considerable detail with the rights and obligations in a certain field, it's intended to be exhaustive. And yet that's a dictum that runs, with respect, completely contrary to the exercise that was undertaken in Marchich. Now, the reason we're here is, unfortunately, although it was cited to the court, the one case that doesn't appear anywhere in the analysis is Marchich. And yet you have, ultimately, a position of, with respect to incoherence. Because you've got the BWB litigation and the 2014 litigation, which are predicated upon a hunt for statutory authority. On the plain understanding, the absence of the statutory authority, the action in question would be a trespass. That's what Lord Sumption says at paragraph 2 of his speech. They hunt through the particular provisions that regulate the powers of discharge and conclude that Parliament has a comprehensible principled scheme of limitation. You can't discharge this type of thing. If you act within your powers, you have to pay compensation. Anything else is a trespass or a nuisance. And yet you have Marchich directed to the general drainage duty in section 94 that says all questions of this kind are only subject to remedy through a section 18 enforcement order. And the two judgments, with respect, do not cohere. Indeed, they conflict. There's only one of three logical possibilities. The adventure in BWB and the MSC 2014 case was a waste of time, because there was never anything requiring statutory authority at all. Marchich is wrong, or MSC is wrong.
Well, I misunderstood this, but I thought the 2014 case was concerned with any discharge into the canal.
It was.
Not discharge of untreated material.
Correct.
So why is there a mismatch between the two cases? They're shooting at different targets, aren't they?
Because the result of the 2014 case is that there is a result of implied discharge, but it's subject to limitations, i.e. thou shalt not discharge foul water prejudicially to effect, cause a nuisance, etc., the very nature of which are inconsistent with the very cause of action asserted in Marchich. That's the problem. The very thing that the Supreme Court has gone to such length to save and to prevent, i.e. the prevention of discharge of sewage, and the very efforts they've gone to revive the application of the provisos to control the power in question and to ensure that whatever happens is compensatable either through statutory authority or through the law of nuisance when you exceed your authority is undone by Marchich. So that's the 2014 case, and you'll be unsurprised to know that that's the foundation of our ultimate request, if we get to it, to apply the practice statements, because having two judgments of this court that so obviously conflict with each other is not sustainable. Topic 7, parallel regulation. I'll take this very quickly. One of the key informing concerns of the ouster argument is the idea that Ofwat has some special protected monopoly on the evaluation of whether or not new infrastructure should be built. It's the Lord Nichols' impermissible message from the common law of build more sewers. But the reality is that there are two parallel regimes of regulation that equally lead to the same message of build more sewers, and do so as a matter of obligation, neither of which was before the court in Marchich. The first is the regime that culminates in the environmental permitting regime and in the urban wastewater treatment regulations. They're the bailiwick of the Environment Agency. The second regime is the regime of statutory abatement, a statutory regime of abatement of statutory nuisances in Section 79 of the Environmental Protection Act. And that, as a result of two cases, Carrick and the Falmouth case, creates a clear duty to to investigate and, where found, require the abatement of a statutory nuisance, including nuisances by undertakings in discharging sewage into watercourses. Carrick and Falmouth were both cases involving undertakers in a maritime rather than riverine context. Now, these two parallel regimes are relevant for 4 reasons. The first is that the urban wastewater treatment regulations flesh out the detail of the Section 94 duty and make it a good deal more granular than it appears in relation to the simple section itself. And that's important if you accept that the Section 18 enforcement process is not nearly as discretionary as the House of Lords thought it might be in Marchurch. If the regime is itself supplying answers to these questions and the role of Ofwat is limited, the contention that the Ofwat remedy ousts the common law is that much less strong. Secondly, you need to understand this regime to understand how the first limb of the Section 1175 proviso works, the proviso in relation to the environmental permitting regime. And to do that, you need to understand what sort of permit breaches are knocking around. Thirdly, you need to understand this to meet the argument now advanced by UU that the prospect of compensation in criminal proceedings for permit breach might be the way that Parliament avoids the consequence of no compensation. We say that's unreal. And then fourthly, the fact that each and every local authority in the land has duties to secure abatement against statutory nuisance, a proposition which would be relevant even to the findings in Marchurch, is obviously of relevance if the consequence of an abatement notice is to require the party abating to build more sewers. And again, it goes to the extent of the regulatory monopoly. Now, the environmental permitting regime is backed by the Water Framework Directive and the Waste Framework Directive. And those two strands then come together in the Urban Wastewater Directive, which you'll find at page 1611.
Just give the page again, please.
1611.
Thanks so much.
Directive.
That's the directive, the Urban Wastewater Directive. And its basic aim is to require, in sufficient concentrations of population, there be collecting systems, that's sewers to you and me, and treatment systems, that's wastewater treatment works, sufficient to handle the requirements of those particular areas.
Which article is that?
It's a combination of Articles 2, 3, and Annex 1. And actually, probably the most important thing is Annex 1, which defines collecting systems and treatment, etc. That's page 1617. You'll see, in relation to collecting systems, that the collecting systems shall take into account wastewater treatment requirements. Their design, construction, and maintenance shall be undertaken in accordance with, this is a thing called BTK-NIC, best technical knowledge not entailing excessive costs, notably regarding volume and characteristics of wastewater, prevention of leaks, limitation of pollution of receiving waters due to storm water overflows. So the whole scheme of the directive contemplates the use of CSOs, combined sewer overflows, and then there's a footnote to section A at the bottom of the page that expresses the view that these CSOs should only work in exceptionally, unusually heavy rainfall. Member states shall decide on measures to limit pollution from stormwater overflows. Such measures could be based on dilution rates or capacity in relation to dry weather flow, or could specify a certain acceptable number of overflows per year. So they're all alternative means to ensure that overflows only operate during unusually heavy rain. Those provisions are then carried over into the Urban Wastewater Treatment Regulations, which are at page 1463. And the relevant bit is at 1466. Regulation 4.1 tells you what's going on. This regulation supplements the Section 94 duty. And then you've got subparagraphs 2 and 3, which are directed at collection systems, and subparagraph 4, which is directed at treatment systems. And that's effectively 94.1a, collection, 94.1b, treatment. And that's why they refer to 1a and 1b respectively. And effectively, 4.2 copies out the provisions of the directive and then inserts a qualification that is not in the directive but part of the domestic implementation. It says that the obligation to build out collecting systems that satisfy the requirements of Schedule 2, and Schedule 2 is in page 1478, it's in the same form as Annex 1 of the directive, shall not apply where either the appropriate agency, that's either the Environment Agency or Natural Resources Wales, its equivalent in Wales, has certified the establishment of a collecting system is not justified because it would produce no environmental benefit.
Sorry, where are you reading?
Paragraph 4.3, Regulation 4.3, my lord, page 1466.
Thank you.
So there's no obligation to build the systems required by the directive if the systems argued for have been certified by the Environment Agency as producing no environmental benefit, or the Secretary of State has certified that the collecting systems would not be justified because of excessive costs. And there are other schemes in question. And this goes to my basic point that the issues about cost for the collecting systems required to address pollution are actually questions for the Environment Agency, principally, and the Secretary of State by reference to excessive cost. These then flesh out the Section 94 duty. Now, in parallel with that statutory duty on the undertaker, there are then the licence conditions or permit conditions. But the permit conditions, introduced under the 2016 regulations, operate generally to do two things. They limit or demand a minimum forward flow through a system at a CSO. So a certain number of litres per second have to get past the system before it starts discharging over its weir. And the discharge over the weir and into the river has to be due to rain or snowmelt. And you can see example conditions at page 401 of the supplementary bundle. These are fairly standard conditions used for these types of permits. If you look at point 6, page 401, the discharge shall only occur where the rate of flow in the sewer, the combined sewer overflow, exceeds 2,700 litres per second due to rainfall or snowmelt, and shall only consist of flows in excess of this setting. And what that's designed to do is to ensure that it's only the unusual weather events that will cause the CSOs to discharge. And that's done by reference to the forward flow rate. But the problem, and the reason why it's quite right to say that this case comes down to insufficient infrastructure, is that sewers that were designed to hold a certain volume of wastewater and have spare capacity of 5 or 6 times that wastewater capacity for surface runoff are more and more taken up with wastewater. So the volume of the water in the sewer is more and more wastewater, such that only light rainfall, sometimes drizzle, will trigger a permit, trigger an overflow. The reason that that's relevant is this. None of that is a permit breach. It's not a permit breach to have a sewer with a CSO with conditions like this that discharges in light rain. It's incompatible with the regulation, but it's not a permit breach. And the reason that that is relevant is the idea that criminal compensation will provide an answer to these problems. It doesn't work, because if there's no criminal offence in any of these circumstances, there's no basis even were you to get into criminal compensation for payment to be made, because there's no underlying permit breach. What we have is a system, and this is what sits behind much of the heat in terms of this whole issue, that on the one hand doesn't criminalise recurrent discharges of this kind, and yet at the other time is insufficient from the perspective of the requirements of the regulations. And that's all a function of a lack of investment. So Understanding how that regime proceeds in parallel explains the limited role, in many cases, of the criminal law in relation to permit breach, and why it is that what's happening is more and more frequent discharges of more and more concentrated wastewater as the capacity in the sewers is more and more taken up to that effect. That's the first regime. The abatement regime you'll find in section 79 of the Environmental Protection Act. Page 1362. The relevant section is at 1379. And it's a scheme of statutory abatement in relation to a number of listed things. If you look down at 791E, a nuisance might be an accumulation or deposit which is prejudicial to health or nuisance. And if you look down to H, you can see a reference to any other matter declared by an enactment to be a statutory nuisance. And one such enactment is section 259 of the Public Health Act, 1936, which is also in the bundle at page 1456. And that enactment makes it a nuisance effectively to have a pond, pool, ditch or watercourse, and it's watercourse, it's a critical word, which is so foul or in such a state as to be prejudicial to health or a nuisance. And in two cases, I think backed by Surfers Against Sewage or their ilk, the courts decided, first of all, that a deposit of fecal matter, condoms, other things that were discharged, gross matter from sewers, was a statutory nuisance under section 79(1)(e) when it washed up on the foreshore of a beach. And there was a duty to investigate such nuisance and when it was identified to secure its abatement. And then in a later maritime case called Falmouth, when no doubt the outfalls had been screened and what was coming out was a suspension rather than solids, there was an argument about whether or not there was a nuisance under the Public Health Act, making the watercourse foul. And in a case called Falmouth, the Court of Appeal...
What's it called?
It's the Falmouth case. The Court of Appeal concluded that the earlier case of Carrick was correctly decided, see paragraph 22 of Lady Justice Hale's speech, but the water body in question, which was an estuary, 7 miles long and 2 miles wide, wasn't a watercourse, and therefore there was no duty to abate in relation to it. But the net upshot of the two cases is that there remains an obligation to abate a statutory nuisance in relation to watercourses. That means that every public authority must take action.
Now, Mr. de la Mare, I'm afraid you've used up your allocation of time.
I've spoken to Mr. Hockman, and he's prepared to give me 15 minutes of his time, so I'm going to wrap up very swiftly.
Right.
The consequence of that is that there is a parallel statutory regime that empowers any number of other regulators, every single local authority, and requires them, as a matter of duty, to take action in this respect.
Can I suggest, if you've only got 15 minutes, obviously it's up to you how you present your case, but I think we would find it helpful to hear you on topic 11 in particular.
I'm grateful. Can I just rattle through topic 8 extremely quickly? There is no compensation remedy. Section 22(2) doesn't work, particularly if no enforcement order is made. You can't get within Schedule 12, for the reasons I've shown you. The Barrett's number 2 case, paragraph 28, page 1940, says all that can be compensated is that which is done within the scope of the powers. So there's no compensation that way. There's no criminal compensation for the reasons I've just described, because in many circumstances there's no crime, and in any event, you only deal with very simple cases through victim compensation provisions. Hardly you're going to deal with damage to a canal or a fishery or matters of that kind. And Section 95 provides no variance, or if it does, it provides only variance for a statutory strict liability scheme that doesn't address damage. And that means there's a gaping hole when one comes to compensation. The problem with Marchich is that there is no engagement with any of these topics or the provisos. Marchich was decided without any consideration of the provisos, without any consideration of Schedule 12, without any consideration of the relevant sewerage provisions, and with no answer to the point under Section 18.8 to the effect that it was an express ouster rule. The BWB case, which had already grappled with all of the provisos, wasn't cited or considered. And the case proceeded without the Lancashire decision, explaining perhaps the more nuanced position in relation to the scope of the duty under Section 18 to 22. There wasn't any argument about the parallel duty under Regulation 4, and there was no consideration of the principle of legality. The kernel of the reasoning was also suspect. For this reason, it was based upon a series of 19th century cases that were predicated upon breach of statutory duty arguments, and there being no claim in breach of statutory duty. And that doesn't answer the position in relation to nuisance or trespass. As we've explained in our written case, the speech of Lord Hoffman also misunderstands the Pride of Derby case, which he reads as supporting Glossop line of authority, when in fact Lord Denning was saying it no longer applied. And that takes you to this position. When you strip it back, the only thing that underpins the ouster argument, and it's really my learned friends' propositions 2 and 3, I think it is, are the existence of a parallel regime with a statutory duty presided over by a regulator. And the inference is that the existence of that regime and that regime alone is sufficient to displace common law remedies in the face of or in the teeth of the operation of the principle of legality in all of its forms, whether it's as articulated in paragraph 58 of MSC number 1, Lawrence, paragraph 88, whether it's Fern, whether it's CPAG, they all take you to the same place. And the answer has to be, when you've looked at the provisos and you've grappled with the fact that they only make sense as a means to modulate the interaction between the continued application of the common law and the statutory regime, and when you start your analysis, as Piggott says you should, with an analysis of the particular powers and the statutory limits on the particular powers, the reasoning in Marchich falls down. Now that means you can do one of two things. You can distinguish Marchich, and there is a principled basis to distinguish its reasoning on the basis that it doesn't extend to cases involving discharges, the subject of implied powers and the excessive use of such implied powers. And there's a strong foundation in the Act itself to make such distinction. Section 94.4, which I have shown you, shows that the general analysis in relation to Section 94 and the remedies in relation to it is without prejudice to the remedies in relation to the balance of the provisions of the Act, and that includes Chapter 2 of Part 4. So you can confine the ratio of Marchich to escapes. I recognise, of course, that that might be thought to smack...
When you make this distinction between escapes and discharges, could you be a bit more specific about what that distinction is? Is it to do with land and water courses, or is it to do with the something that's always planned to happen and
Yes.
something that accidentally happens, or what is the distinction
A discharge is a planned outlet that's authorised to operate in certain circumstances. So a CSO, combined sewer overflow, overflows in planned circumstances. Emergency outflows from wastewater treatment works work in certain circumstances. The general outflows from wastewater treatment plants to discharge treated water work in planned circumstances. Those are all discharges that require, first of all, environmental permitting, and secondly, they require consent on the part of the landowner into whose lands they discharge or whose water body they discharge, and they are part of the system design. A Marchich case, an escape of sewage coming out of a manhole cover because it's been forced up by pressure in the system, and that's the only place it can come out, is an escape. And it's the distinction Mr. Justice, I think it's Upjohn, in one of the cases himself makes. I can't remember the name of the case now. But Smeaton.
Smeaton.
Smeaton. And it's a distinction reflected by the general drainage duty, which is in Chapter 1 of Part 4, and the very series of powers conferred and duties conferred in Part 4, Chapter 2, which are all about system design, so the duties to connect, the implied authorities of discharge. And the relevant sewerage provisions are really designed directed at those parts concerned with the deliberate design of the system.
Is this Smeaton and Ilford Corporation? Is
Yes.
it? Right.
Would it make more sense to say that you can have compensation for a nuisance for an escape, but not for a discharge? It seems a bit counterintuitive to draw a distinction to say, well, Marchich is right to say there's no right for a common law claim for an escape, which is an unplanned thing, but that there is a right for compensation for a nuisance caused by a planned thing.
The critical difference is that in relation to discharges, they arise as a result of a deliberate exercise of statutory powers. And in the case of a discharge into a canal, it's the power of discharge arising from section 116. And what we're concerned with in this case is the legal consequence of an excessive or unlawful use of that power, which contravenes the limits on authority that Parliament itself has set upon its use. And I go back to my point, the whole function of the provisos is to identify the limits between statutory authority and that which is unauthorised and therefore necessarily re-engages the common law, just as it always does in a principled system that looks at statutory authority, compensation and ouster. And I go back to the point I made in opening. The only case where there has been an ouster of a remedy in relation to something that is completely unauthorised and contrary to the statutory scheme is Marchich. And it's that feature that is, with respect, both singular and I would suggest aberrant.
Are all discharges into rivers, canals, ponds?
Are they all?
Are they all into waterways?
They're either into waterways or the sea. Yeah. Okay. Yeah, that's the.
But you wouldn't say that an escape of sewage would in any sense be statutorily authorised, would you?
No, it doesn't even begin to engage a power of statutory authority. The difference between an escape and a discharge is that much of the time, a discharge may be operating perfectly lawfully. If it's not operating to discharge at a level causing a nuisance, let's say it only works once every 30 years in an enormous storm, and the sewage is heavily diluted by rainwater, both the dilution and the infrequency is unlikely to cause a nuisance. That's the singular point here. It's the fact that certain uses of the sewers exceed the statutory authority, just like the use of the power in Piggott to put more water over the pass exceeded the limits on that power, which were to say, don't interfere with the milling power of the stream. And that's what constitutes the basis for a distinction. But let me be transparent. If you're unconvinced by that, and it smacks of the types of distinction that this court used to make before the 1966 practice direction, it constitutes the type of distinction that used to be made under the London Tramways line of case law, which this court is moving away from, then we don't resile from saying Marchich is wrong, and this court should depart from that authority. It's wrong on the merits for all the reasons I've given. Once you look at the regime as a whole, it's impossible to identify a coherent and consistent scheme, still less one that complies with the principle of legality. and the ouster is predicated on a mistakenly enlarged view of Ofwat's enforcement regime and an enlarged view of necessary remedial conflict between enforcement orders and injunctions. And an important point to note is that there is no remedial conflict on the plane of damages. And the proof positive of that is the fact that Parliament has made some regulations requiring strict liability payments to be made. There's nothing that is a remedial conflict in requiring the party or parties who are benefiting from the discharge, which is the public in low water bills and the undertaker, from paying for the damage caused to the private rights holder in question.
And so the distinction is between discharges and escapes as opposed to discharges into water bodies and escapes of sewage onto land. The relevant distinction, you say, is not the location, the place where the discharge, where the sewage is, but rather whether it's a discharge or an escape.
Yes. Now, if you're with us, the case of Marchich, if you were deciding it afresh, is wrong. That's obviously only the first bar I have to cross. We accept that there's a substantial additional bar, and this court will be very circumspect, as was explained in Noah, to depart from its former rulings. And perhaps the most clear insight into the criteria to be used are the FII case criteria at Supplementary Bundle 11, page 249, where DMG, so far as it dealt with limitation, irony of ironies, was overturned. And the basis was that the results were contrary to first principle, illogical, and led to incoherence in the law. And we say that that test is met here. It is contrary to principle to have an ouster that operates only to immunise, without compensation, unlawful activity, whilst insisting for full compensation for that which is done lawfully. It is contrary to principle to have an ouster that rewrites an express ouster clause in section 18.8, and it's contrary to principle, illogical and incoherent to strip the provisos of any comprehensible meaning, operation or function, and in the case of 186 in particular, to make it into an absolutely unintelligible jumble. But beyond that, we say that there are two factors that point even more compellingly in favour of the application of the practice direction. The first is the development in the law that is the 2014 case. And if you're with me, that Marchich, ultimately taken to its logical conclusion, conflicts with the whole exercise in the 2014 case, which was to save the operations of the proviso and to save the operation of the compensation provision, to make sure that the law offered a consistent face, that that which was authorised was compensated, and that which was excessive in Parliament's view was not authorised and therefore tortious. If you're with me with that, then the fact that Marchich and its logic might, by an unintended sidewind, have overruled a host of cases like BWB and Pride of Derby that thought there was a claim in those circumstances, and by unintended sidewind to have rendered the provisos meaningless is the strongest reason to intervene. The second reason to intervene is that this is a case involving the principle of legality, and if you're satisfied that the result doesn't comply with the principle of legality, that is a high-order principle in and of itself that compels the application of the practice statement. And the third high-level reason is that the law of injunctions, which plainly informs all the 19th century case law on which Marchich was born, and the very fear of remedial inconsistency, provides an alternative route through this, now that we've seen that the law is as in Fern and Lawrence. And the place to deal with potential remedial conflict is in the grant or refusal of injunctive relief and or in the measure of damages that is awarded for nuisance in a case such as this. Unless I can assist you further, I will hand over to Mr. Holland.
Can I just ask you this? The point that might be made against you is that some 20 years have now passed since March. Parliament has legislated in relation to this area a number of times. They brought in a compensation scheme. Why haven't they corrected it?
With respect, that's a point that's always made. If you look at
Well,
every
it doesn't
single...
mean that it doesn't have any substance.
Mr. McDermott made exactly the same point in the Nower case. It was made in DNG.
So what your response is what? The point?
My response is that the expectation that Parliament will be operating to modulate the law is not always a safe one, for the reasons given by my Lord Burrows in his book on statutory interpretation, that's not a safe assumption that one can simply have recourse to the expectation that Parliament will intervene.
Yeah, but it
and
may
act.
go the other way around. The point is that Parliament has not intervened.
Indeed, my Lord, but I think...
It's not an expectation they will. The
No, I
fact is
understand,
it
I understand the
hasn't.
point, but...
Well, I just want to know what your response is.
Well, I think having had a flavour of the complexity of this case and of this legislation and the regime it interlocks with, it's remarkably dense to suppose that it was immediately appreciated that the impact of the Marchich decision would be these consequences some years later. Well, it's taken us this much litigation to establish A, that Marchich might apply in this case, and B, that it produces the effects of undoing the predating BWB litigation and the 2014 litigation. And the reality is, you can't have both the 2014 case and Marchich both subsisting. They have to be reconciled by one means or another. And if you're with me on that, that is the basis to say the court must clarify the position produced by its own judgments. And that's a task for it, not for Parliament.
Yes, Mr. Hockman.
My lords, my lady, I have a similar task to Mr. de la Mare in the sense that I've got quite a lot of ground to cover in quite a short time. I can begin, if I may, by saying that we are very happy to adopt, if we may, Mr. de la Mare's submissions, obviously without repeating them, and subject to a difference of emphasis in relation to the question of remedy, which is one point that I want to deal with. Could I begin by reminding you that Mr. Cleaver, who sits behind me, and I appear before you today on behalf of the Environmental Law Foundation. We're instructed by Sarah Moore of Messrs. Housefeld Solicitors, who the court should be aware are acting pro bono. And I do want to say that the foundation is deeply appreciative of the opportunity to intervene and to make these brief oral submissions. I'm going to try and do three things in the course of the next 26 minutes. Firstly, I want to make some general introductory comments. Secondly, I want to make some points in support of the primary submission that Mr. de la Mare made, to the effect that your lordships should depart from the Marchich case. And thirdly, if I have time, I shall address the question of the distinction between this case and Marchich. So I'll put the distinction point last in case I don't get to it, because our primary argument really and our primary position is to support what Mr. de la Mare has said about departing from the Marchich case. So by way of introduction, perhaps I might just say with regard to the Environmental Law Foundation, and in case the court is not aware of, or has not until now been aware of its existence or of its role, it came into existence some 30 years ago, thanks to the efforts of a very far-sighted solicitor called Martin Polden. Together with others, he saw the need for a new voluntary institution which would help ordinary members of the public concerned as to growing environmental issues to have affordable access to both legal and scientific advice and assistance. And the foundation continues in that function today. Now, I don't need to spend more than a moment on the factual background and the evidence in the case, but I do want to draw to your attention the witness statement of Sarah Moore, which is at electronic bundle page 642, and the witness statement in response by Mr. Smith, which is at page 10, I think, in the supplementary bundle. Our submission is, and I put this very, very concisely, that on a fair reading, there is no effective challenge to three key points made by Ms. Moore, namely, that sewerage undertakers could be releasing unpermitted sewage discharges into rivers and watercourses, that budgetary cuts have impacted on the ability of the Environment Agency to fulfil its own regulatory functions, and that the discharge of raw sewage can be very harmful to human health. Mr. Smith's evidence in response, I hope it's fair to say, focuses principally on the extent to which the respondent is or is not a particular offender in terms of the frequency and duration of such discharges. He makes various points about that. One of his less impressive points, perhaps, is what he says about Lake Windermere, when he says that phosphates enter the lake from the respondent's assets, and they enter the respondent's system as a result of products such as detergents and shampoos which customers put into the network. Not exactly an answer to the increasingly widespread concerns about the situation, because after all it is their job to deal with pollutants that enter its system. But I emphasise that we do not invite this court to reach conclusions on disputed issues of fact as to the precise scope of this respondent's responsibility for any past, present or future environmental impact. We rely on the evidence of Ms. Moore in support of the submission that there is currently an indisputable societal problem arising from the actual or potential pollution of water bodies up and down the country. A problem which can be contrasted starkly with the information as to the profits achieved and dividends extracted by the water companies over the last decade, as set out in paragraph 31.4 of our written submissions at page 191, and in the detailed paper, which is at page 4257. And may I just make this comment, perhaps partially in response to the question raised towards the end of Mr. Delamere's argument by my Lord Richards. We submit that it's plain that the gravity of this problem is something which has really become much more apparent in recent years, and that the fact that 20 years have elapsed can easily be explained by the growing consciousness of what I have called a really serious societal problem. And we respectfully suggest, therefore, that in the end, the issue before this court could even be seen as one which is almost constitutional in nature. The effect of the decision of the judge and of the Court of Appeal is that the statutory scheme has, by abrogating common law rights that would otherwise exist, placed severe limits on the role of the common law and hence of the judicial system in addressing this grave societal problem. And moreover, the statute has had that effect, not by clear words, or indeed as a result of any process of construction of the text that Parliament chose to enact, but purely by the statute existing and by imposing obligations that are thought to be in tension with those that the common law would otherwise impose. Do the courts in this country, we would ask, truly have such a limited role in relation to the solution to this problem? And is the matter therefore entirely one for Parliament and the Executive, even though nothing in the legislation itself says that that should be the case, and several of its provisions, as we've heard, suggest otherwise? Or do the courts, in some cases at least, retain the role which they had before the decision of the House of Lords in March, to intervene in specific claims against water and sewerage companies, now operating, of course, in the private sector? Now, turning to the legal submissions that we want to advance, I'd like to start, if I may, by underlining the arguments that the court has already heard about why it would be open to the court to depart from the Marchich case, And I want to make reference firstly to the case of Marchich itself, secondly to the Fen Tigers case, and thirdly, and briefly perhaps, to the case of Fern. I want to remind the court first that in the Marchich case itself, it was Lord Nichols, in giving the leading speech in the House of Lords, acknowledged that certainly in the case of Mr. Marchich, as he put it, matters plainly went awry. He himself acknowledged that the scheme had not produced a fair outcome, and that it took many years before that was recognised. Although what Lord Nichols said was that the malfunctioning of the statutory scheme, which was his phrase, did not, in his view, cast doubt on its overall fairness. But even at the time of the hearing in the House of Lords, he identified a serious defect in the scheme as it existed at the time of the events complained of, in that there were no arrangements, even for the payment of compensation, to those who, like Mr. Marchich, whose garden and potentially whose ground floor rooms were invaded by raw sewage. And so what we would ask is, if one can imagine a situation in which by the date of the hearing of the case of Marchich in the House of Lords, the actual physical problem had not been rectified, if one can imagine a situation in which that hearing took place when Mr. Marchich's garden was still invaded regularly by raw sewage, is it likely the House of Lords would have arrived at exactly the same wholly preemptive decision? I use the word preemptive, which comes from an article which is in the bundle by Professor Maria Lee. And if no arrangements had subsequently been made, is it remotely likely that any court could conclude that the scheme was fair and satisfactory? In making those comments, I would just like to refer in the report of the Marchich case itself to the summary which is given as to the way in which matters eventually were rectified. It's worth reminding you, and I'm looking at page 1135 in the electronic bundle, it's worth reminding you that following the decision of the Court of Appeal in the Marchich case, which was on the 7th of February 2002, within a month, the regulator had decided that sewerage companies ought to deal more speedily with the more serious sewer flooding problems, and certainly by the time of the hearing of the case in 2004 in the House of Lords, that work had been done. And lest it be thought that the kind of work that is necessary in such cases and the kind of remedial measures that need to be taken must always be something vast, costing millions, if not billions of pounds. We see from paragraph 27 in the speech of Lord Nichols that all that was involved was a scheme alleviating sewer flooding to 10 properties, 7 suffering from the risk of internal sewer flooding and 3 from the risk of external flooding. Mr. Marchich's property was one of these. Work began in April 2003, within roughly 14 months of the decision of the Court of Appeal, and it was completed in late June 2003 at a cost, admittedly in monetary values at that time, of only £731,000. So we are not necessarily talking here about the expenditure of vast sums of money.
So what are you saying, that a claim of nuisance does exist
Absolutely.
when there's a lot more money at stake than when there is less money at stake?
No, I'm simply, my argument is, and I don't want to repeat what the court has heard already, but my argument is that the decision in the case of Marchich that a claim in nuisance and indeed a claim in trespass are ousted, that ought not to represent the law. That the court should decide that the law that those tortious claims are not ousted, and I'm simply saying that the court should not be deflected from coming to that conclusion by the idea that every single case in which the court has to find that there is liability would lead to an absolutely enormous change in the position of any particular sewerage undertaker. It might be something that could be remedied quite straightforwardly. That's the point I'm making. It's a very simple and basic point. And the conclusion that we would seek to draw is that there is a role for the courts in intervening contemporaneously or even earlier at the stage when harm is threatened to occur, rather than months or years later through action by the regulator, by government and or by Parliament. That those approaches to this grave societal problem are insufficient in themselves, and that the courts, in intervening either in advance when harm is threatened or contemporaneously with the occurrence of harm, have a role to play in helping to achieve overall fairness. Of course, there may be cases in which, in the light of evidence and explanations from the water company or from the regulator, the court will decline to intervene. But we respectfully submit that in 2023, the courts should decide in principle that they can play a part in arriving at a fair solution, rather than, in Professor Lee's phrase, leaving the field in its entirety. At the very least, there may be cases, of which the case of Mr. Marchich would, in the absence of remedial measures we submit, have been one, in which the court might decide not necessarily to grant a specific remedy, whether in the form of an injunction or compensation, but at least to adjourn the question of remedy pending further actions or explanations from the water company or the regulator. And we pray in aid, just as Mr. de la Mare did, the flexibility that the courts now have as a result of the Fen Tigers case. Now, let me make a specific reference, please, to the Fen Tigers case in order to remind your lordships of what was said there about the question of remedy. The passage I have in mind is in the judgment of Lord Neuberger, starting at page 2817. And it's headed "The Award of Damages Instead of an Injunction." In essence, over a number of pages, and I won't take time to go through them all now, in essence, over a number of pages, Lord Neuberger discusses the possible remedies and explains that the position going forward should be one of flexibility. At paragraph 101, he does take as his starting point that the initial remedy in the case of nuisance was to be an injunction, that Lord Cairns Act gave power to award damages instead of an injunction, but that both aspects of that remedy should be available. And we would certainly ask this court to emphasise that the appropriate remedies in the case of nuisance or indeed trespass might be compensation, certainly, but might well, in particular cases, be an injunction. And there is a particular sentence in this part of Lord Neuberger's judgment which I would like to highlight, which is at paragraph 124 on page 2822, in which he says, "I do not see why the court should not be entitled to have regard to the fact that many other neighbours, in addition to the claimant, are badly affected by the nuisance as a factor in favour of the granting of an injunction." I think a point was raised earlier as to the possibility of successive riparian owners, successive owners of land through which a river passes, potentially having complaints of a similar nature to the complaint being made by the particular claimant, and that comment by Lord Newberger is plainly relevant to that issue. So it seems to us with respect that, yes, the flexibility as to remedy provides strong support for the argument that this court could now depart from the Marchich decision, but we suggest that flexibility includes the possibility of an injunction as well as compensation, even though the appellants in this case are interested in compensation and nothing else.
So in the Marchich case, if the work hadn't been done and the court had been informed that it was a mere £713,000 for 10 houses, £70,000 per house, are you suggesting that an injunction would therefore have been issued in that case?
Could have been. Yes, yes.
Is that the court then? Where does one draw the line? Enormous costs obviously are outside the court's jurisdiction, but where do you draw the line?
It must be fact-specific, my lord. It must be done on a case-by-case basis. That is the implication of the holding by the court in Fen Tigers, that the courts have complete discretion. And it will depend, no doubt, among other things, on the severity of the tort, the gravity of the tort on the one hand, and the remedial measures. It will depend on evidence from the regulator, and in the cases that deal with this, including not only Marchich but Dobson, for example, the regulator has given extensive evidence as to what its plans are. And like Mr. Delamere, I'm not suggesting that there will inevitably be the grant of an injunction, but I do suggest, based on what happened in Marchich itself, that it would be right for the court to allow for the grant of an injunction as well as damages as a legal possibility. I don't take the argument any further than that. I wanted to make a brief reference to the case of Fern, because we noted in the case of Fern that Lord Leggatt made clear, and this is at page 2340 in the bundle, that a key element in 2340, a key element in the cause of action in nuisance was what he called the priority accorded to the ordinary use of land. He pointed out that this feature of the law of nuisance was already well established in the 19th century, even though its prominence had perhaps diminished in more recent times. And I must accept, I fear, responsibility for failing to ensure that the 19th century authority of Bamford, cited and relied upon by Lord Leggatt, failing to ensure that 19th century authority was cited to the House of Lords in Marchich. I didn't do that. But now we understand, thanks to the Fern decision, the importance of the priority accorded to the ordinary use of land. And it's worth making that point because it was Lord Nichols himself, in the case of Marchich, on which the respondent here so heavily relies, it was Lord Nichols himself who described Thames Water in the Marchich case as no ordinary occupier of land. That is at page 1137. And our submission would be that following the case of Fern, there must be at the very least a strong presumption against interpreting a statute so as to confer immunity upon a defendant in that category. So I hope that that provides your lordship with a little bit of additional legal material in support of the fundamental arguments of Mr. de la Mare. I don't seek, of course, to revisit the specific points of statutory construction or the arguments based on the 2014 case. I haven't time to do that, and I couldn't improve on what Mr. de la Mare has said about those things. May I conclude very, very briefly by suggesting perhaps the following comments to support the alternative argument of there being the possibility of distinguishing Marchwich. And what I want to say about that is the following. Firstly, our submission is that it is absolutely clear when you read the speeches in Marchwich that the decision was a decision concerning the tort of nuisance rather than a decision concerning the entirety of the law of tort. The House was not asked to hold, and certainly did not hold, that there was a complete ouster of all common law claims, express or implied, including trespass as well. So trespass, we submit, on any view, would survive. And it's also worth noting that both Lord Nichols and Lord Hoffman pointed out that in the case that they were dealing with, a case of escape onto land, the older cases did not allow a nuisance claim in respect of the facts of the Marchwich case. And essentially what they were saying was that they did not agree with the attempt by the Court of Appeal in that case to develop the tort of nuisance by reference to the Sedley-Denfield case in the House of Lords. In other words, the starting point of their analysis was that there was no existing common law right of action in nuisance on facts such as those that were in issue. The relevant question in Marchwich was whether the common law should be developed so as to recognise such a claim in circumstances where Parliament had already legislated in the relevant field. But what we go on to say in our written submissions, and I remind you that those start at page 173 in the electronic bundle, what we go on to point out is that factually the Marchwich decision related to the absence of a claim in nuisance in cases of flooding on land. Neither previous authority nor the case of Marchwich itself precluded claims relating to the discharge of insufficiently treated sewage into water. In those circumstances, the common law gave effect to a claim in nuisance, and we rely ourselves for this purpose on the Pride of Derby case, which is at page 3204 in the bundle. So, to pinpoint the argument that I seek to make, while in Marchwich the question was whether the common law should be developed so as to recognise a right of action in circumstances where one had previously been unavailable, that is not the relevant question in this case. It's one thing to hold that the existence of a statutory scheme leaves no room for the development of new common law claims that might be inconsistent with it. It's another to hold that a statute has abrogated claims previously available at common law, despite the legislative text expressing no such intention. So on those grounds, if our primary case that Marchwich should be overruled does not appeal to the court, then our alternative argument is that it can be restrictively distinguished, and on that ground too, the court should hold that in the case of discharges into water, the common law still has a significant role to play.
As regards your point 1, if I may.
Yes, Mike.
Sorry, have you finished?
Yes, I have. It's 4 o'clock.
Can we, in any sort of principled way, distinguish trespass from nuisance, do you think? I mean, you said Marchwich is only a decision on nuisance. I mean, is there any way in which one could justify that in terms of principle?
My Lord, I suspect that our answer would be no. And what we would say is that that our point on that is perhaps, as it were, an argument of last resort, a fallback argument, if you like. In other words, if our opponents succeed in persuading you that Marchich is still ought to be followed, ought not to be overruled, then at the very least we're able to say that it applies to nuisance and nuisance alone, and that it doesn't apply to trespass, and that an action in trespass can still be brought. That's the way I would put it. But I respectfully agree with your lordship that if the arguments of legal principle, which Mr. de la Mare and I have endeavoured to put forward, are correct, then there is no principal distinction between the two. Unless I can be of any further assistance, I think that's all I can
No, thank you very much, Mr. Hockman, and we're most grateful to the Environmental Law Association for their assistance. We'll adjourn now and resume at 10:30 tomorrow morning.